I call Christopher Farford.
Thank you very much, Mr Chair. I've just decided to take a call on the Child Protection Child Sex Offender Register Bill because every so often I think a select committee does a good job of making a bill better, and I think when I look at clause 48, which is around restrictions of change of names for child sex offenders, that they've actually done a good job. There was some concern from the Attorney-General that the permanent prevention of changing names by child sex offenders was against the Bill of Rights, and I think the Office of the Attorney-General did submit to the Select Committee that it was probably not the best idea to have that completely absent from the bill. And there's also another members' bill that was before the House, and I think may have been before the Select Committee, that looked at preventing name changes for child sex offenders permanently. But I think this approach that's within the bill is better, because instead of going to the Registrar of Births, Deaths and Marriages to change a name, someone who is placed on the register because of being convicted has to go to the Commissioner of Police to be able to change their names. And that comes under 48B. And if the Commissioner is going to consider that, there are a set of criteria which he or she, I should say, will have to look at in order to change a name. There can be some scurrilous reasons for a child sex offender to potentially change their name and therefore not be on the register, but there might be some perfectly valid reasons for someone to change a name. Getting married is probably one of the most obvious examples of that. But 48C does run through what I think is a better way to attack the issue that members' bill was, and that the Commissioner of the Police has to take into consideration when someone is applying for a change of name, the safety of the registrable offender and other persons, B, the registrable offender's rehabilitation or care or treatment, C, whether the proposed name change could be used for further unlawful activities, D, whether a proposed name change is likely to frustrate the administration of the Act that we're debating here, and finally, whether the proposed name change could be considered offensive to a victim of a crime or immediate family member of a deceased victim of a crime. I think that is an extremely sensible way to address the issue of people who might be on the register changing their names. Instead of the other alternative that I believe was before the committee, which sought to prevent permanently the changing of names of people who may have been on the register. So I'd like to thank the committee for taking a rather pragmatic and also point of view and perspective, and also taking into account some of the concerns of the Attorney-General. I think that this change in this piece of legislation is a better balanced and practical way to address the issue of name change. And I do note that Mr Ducey mentioned this issue as well, but this select committee has listened to the issue around this specific part of the bill. There may have been concerns in the community about it, but taking a rather blunt instrument of permanent prevention of name change in the members' bill that was proposed, and I understand that isn't going to go through now, is a much better way, instead of filling the ballot with meaningless and stupid members' bills.
Mr Chair, I call Stuart Nash.